Good evening and welcome to the regular meeting of the City of Morgantown Board of Zoning Appeals. Please turn off all cell phones or other devices that may disrupt these proceedings. It is the duty of this board to consider requests for relief from the requirements of the city's zoning regulations, to consider conditional use requests, and to hear administrative appeals. The board conducts business in the following order. We will review, amend, and approve meetings of a previous meeting. We will move to unfinished business, move on thereafter to new business, and then entertain announcements from staff. Each request is heard in the order that it appears on the agenda. For each conditional use and variance request, the following is done. I will introduce the agenda item, and the Planning Division will present a staff report which may or may not offer a recommendation. The applicant agent will be asked to present their justification for their request, which may include questions by members of the board. We will then open a public hearing to hear testimony in support of or in opposition to the request. Rules regarding public testimony are as follows. Anyone wishing to testify during the public hearing may do so once recognized by me, or may, in lieu of oral testimony, submit written testimony to the chair. All recognized speakers must approach the podium, state their name and address for the record, and speak clearly into the microphone. All comments must be addressed to the board, should be relevant to the application in question, and may not be of a personal nature or personal attacks. All speakers will be limited to 5 minutes. If members of the board have any questions of the speaker, that time will not be counted toward his/her 5 minutes. If there is a large number of speakers, including many who are part of groups or organizations, we may, to avoid repetitive comments, elect to ask for a representative to speak on behalf of the group or organization for the petition. Speakers are notified that irrelevant comments or comments of a personal nature or personal attacks may result in the speaker forfeiting his/her opportunity to participate in the public hearing. I may elect to recognize the applicant agent at the end of the public hearing to provide rebuttal or additional comments, which will be limited to an additional 5 minutes. If members of the board have any questions of the applicant agent, that time will not be counted toward his/her 5 minutes. After all testimony is heard, I will declare the public hearing closed and no further public comment will be permitted. Uncivil, unruly, and/or disruptive behavior at any time during this meeting is prohibited and will result in removal from this public meeting. State law requires the board to consider findings of fact for each conditional use and variance request. The request cannot be granted unless a majority of the quorum present finds in the positive of all of the findings of fact. The board may elect to continue the hearing to another date if it needs additional information. Applicants and requesting parties will be notified in writing by the Planning Division of the board's findings and conclusions. Regardless of whether a request is approved or denied, decisions of the board can be appealed to the Circuit Court of Montague County within 30 days upon receipt of written notification from planning. Any work done relating to decisions rendered by this board during this 30-day period is at the sole financial risk of the applicant. Thank you for your consideration and respect for these proceedings and the opinions of all meeting participants. We're going to call to order. Ms. Cook?
Here.
Ms. Felt?
Here.
Mr. Benison's present, and we would like to state for the record we do have quorum, so we can continue. We need to consider meeting minutes from the February 19th, 2025 meeting. Any issues or changes or emendations or nothing else? All right. I move to accept the meeting minutes from the regular meeting, February 19th, 2025.
I second.
We have a second. All those in favor of accepting minutes?
Aye.
Aye.
Aye. Said minutes have been duly accepted into the record. So we have, under old business, we have VAR 24 121 Brenda Hughes, 120 Doyle Street. Request by Brenda Hughes for variance relief from section 1331 of the city's planning and zoning code regarding accessory structures and uses in residential districts. City tax 14, District 14, excuse me, 6th Ward, tax map 33, parcel 34.5 in the R1A Service Business District. Is that listed correctly in the R1A?
Yep, they're all
That is correct.
Single family.
Okay.
Residential.
Okay.
Yep. So, starting off, the applicant seeks to move a shed at the above referenced address. This shed would be set 24 feet 6 inches back from the front property line. Please refer to the staff maps and submit documents below for additional information. There shows attached in the report, as well as what was sent out, just kind of a parcel as well as the neighboring parcels, just to give its location. This is a bit of a easier, to see the actual kind of landscape top down of the property, being 120 there, where you can kind of see the house. It's a little bit easier to see in your packet. And the next one shows their plan of where they're kind of taking it and shoving it back. As it says there, for that 24, excuse me, and a half feet from the property line there. Based on the conditions listed above, the applicant is requesting the following, which is variance relief in the form of allowing an accessory structure positioned in their front yard. And that concludes staff report.
So, this is material the same, what was proposed
Could you elaborate?
previously?
Yes, yeah, to my understanding. That was before my time with the city, but I believe so.
Oh, all right.
It's a shed that is currently positioned there, where it's kind of shown on that. And they are bringing it farther back, and the variance being asked for is it being permitted in the front of their property.
Mm-hmm.
Since there isn't any like setbacks for an accessory structure in the front yard, it's just permitting an accessory structure being allowed in a front yard.
Right. Thank you. Thank you, Mr. Thompson. Do we have a representative for this case?
I'm Mrs. Hughes.
Would you like to speak and?
Sure. The reason you denied me last time is because I didn't have the exact measurements from how far I was going to move the shed.
Yeah, thank you. Can you just, you did state that you were the applicant, but can you state your full first and last name and address for the record? Thanks.
Brenda Hughes. And the reason you denied me before.
Address?
120 Doyle Street,
Thank you.
Morgantown.
Yes.
The reason you denied the motion before was because I didn't have the exact measurements
Right.
on how far I was going to move it off of my neighbor's property line.
Right.
Which right now I think it's a couple inches on their property.
Right.
But now I do have the specific measurements, so that's why I'm coming back to you to get approved.
Right. So it's material the same application as previously. You just have more supporting
Yeah, I have the
visual
measurements.
documentation.
Exactly.
Okay. Any questions?
Did you bring them or?
Brenda?
Yes, can we see did you get it measured out where we can see the measurements?
Yeah, it shows you there. It's a little hard to read.
It is. If you want to point to it, I'm
Yeah.
good with that.
It's a little blurry.
Yeah, it's very,
Yeah,
very
it's-
difficult to read.
It is. I'm sorry about that. It looked a little bit clearer on paper, but I guess when it was copied, it doesn't look as clear.
No, it doesn't.
But it's 24 and a half inches away from the property line. Or, I'm sorry, feet.
Currently it
Feet.
is? Its current location?
No, that's where we want to move it. Right now, it's probably about,
14 to 27.
I would say, probably maybe 6 inches on the property line.
Right,
So we want to move it 24 and a half feet away from the property line.
right. So basically right in front of your principal structure, labeled
Yeah.
as dwelling.
Right.
Are you, just to try to contextualize this, are you moving it onto a slab at all, or
No,
piers?
what the people do when they deliver these pre-made sheds,
Right,
they put them on cinder blocks to level them up.
right,
So the person that delivers it, I have to have them come back out, and of course, they'll lift it up, I assume.
recite it.
Yeah, and they'll put it on cinder blocks and all of that kind of stuff and re-level it.
Right.
And there's no separate set off from the adjacent property line requirement?
Well, I mean, yeah, Mr. Thompson, can you speak to that? I mean,
For
It's-
example, the
the
property line over.
yeah, I mean, it's an irregular lot.
Correct. Yeah.
That's a
For-
challenge.
If this being approved and then denied or whatever, the accessory structure would have to be permitted. So it'll go through the normal procedures of a building permit for an accessory structure. But the requirements would be, it would have to be at least 5 feet away from that, we'll just refer to it as the western property side.
Right.
So it'll have to be at least 5 feet away from.
Which
the
it looks, I mean, it will meet that
Yeah,
requirement.
going 24.
Going 24 feet back.
Feet back, they should be within 5 either way.
Right.
But there's no real, for an accessory structure, there's not really a standard for it. It's relation to property, like the front yard property line. It only refers to the rear and side yards, which is 5 feet.
Oh, so there's no setbacks for the front because there's not supposed to be anything in the front.
So it's not even, it's not the
What's-
distance that we're granting, it's basically, we're granting the
That
right
it's in the front of the
to
property.
site it in the front of the principal structure.
When was the original hearing for this?
Could you repeat that, Ms. Cook?
Do you want to repeat the question, and then we'll address your
Well, I was
question?
saying, he was saying, so what we're granting is that it be in front, in the front of the property.
Correct. The variance is being, allowing an accessory structure in the front yard of the property.
And the reason for that, correct me if I'm wrong, it's topographic variability.
Right,
On the other side of the principal, well, there's
Right.
just, it's too
right.
topographic.
The one side I can't do because it's too close to their property. The other side would be not accessible. And in the backyard, I cannot do because there's actually a utility access road that goes in behind my property, that whenever I had purchased the property, they said that we cannot put anything that is permanent on that
Yeah.
in case they would have to access that at some point.
Yeah, that makes sense. Because they have full
Right.
rights to that easement,
Yeah.
unencumbered access through that easement.
Was this one where there was like a opposition from the neighbor?
We're here.
Okay, I remember this now.
It was contentious. So this was probably, do you remember when? It's probably been 6 months since you were last here, right?
Probably.
Right.
And the
Well,
front,
maybe not that. I think it was February, maybe.
Oh, that recently?
I think so.
I thought it was last fall. Okay.
That range sounds correct. It would have been before I
Before you
was
came
on
in.
board.
And I'm surprised that you weren't present for that. Initially, that.
It was the
case.
one just before.
Right, okay. So those,
I don't,
those,
so I mean, there's, the reason it couldn't go, say, here or here is why? Because of the setback requirement on that side of the property?
Right.
That could be their reasoning to, Yeah.
Wouldn't that be maybe less objectionable to the neighbor, and that's also a variance request, wouldn't it?
There's
Isn't
not
it?
enough room.
I don't think there's enough room for the signs.
Okay.
And
So there's nowhere else, there's no other side to
No.
put this structure?
I think so.
There couldn't be a variance requested to go on a different side?
No, there's no way to access the other side. And like I said, there's not enough room on the side in between us.
It's basically materially the same application as before. It's just we asked to table it because
Because I didn't
the
have
document,
the
it wasn't
information.
clear.
Yeah.
It wasn't clear, just in terms of documenting what exactly are we
In measurements.
granting the variance for.
And there's no way to get to the back, right?
No, because there's a topographic variability and the easement's back there.
I mean, this is a little off topic, but I guess, so you do have I'm assuming you have an easement to use that drive?
I'm sorry?
I'm assuming you have an easement to use that gravel drive?
Yes.
Okay. Okay. All right.
So materially, it's the same petition, it's the same application, it's just, yeah, we will. Would you like to add anything else in support of your application? No? All right. So we may call you back
Okay.
to provide rebuttal, possibly,
Okay.
or more information.
Okay.
Any other questions?
Not just.
Okay.
Okay.
We can, I guess, thank you. So I think we'll just, anything further, Mr. Thompson, to add?
At least on the staff report side, I can go through a little bit of the recommendation kind of section.
Why don't we do that first, and then we'll open the public hearing.
Staff have no objections to the applicant's request for variance relief if the Board of Zoning Appeals does grant the applicant variance relief from section 133108A2 of the city's planning and zoning code. The new addition, the new accessory shall be subject to the following conditions. You can read it, it's in the staff report, but it's effectively the one that says this is the only variance relief that they are being given. And if something was to change or anything along the lines other than what's presented here today, they would have to seek variance relief if they would require variance for that. Example being if they were to set it back however far they were encroaching on their side setback, then they would have to seek another variance or put it within that like 5 feet side, for example.
So they're probably going to be back here, even if this is granted. They might still have to be back here for an additional variance.
If this is granted and then they would make changes, other than what's presented today, that would require a variance, then yes.
I think the citing is where the applicants opted to cite it, she's trying to take into account the sides and to be within the range, to avoid
The applicant
subsequent
would also need to acquire an accessory structure permit to have it permitted to be built. So that
That's
would be
through
another-
planning, though.
That would be through all of the departments. Code, planning, fire, MUB would be another
And
one.
MUB too.
So they would have to see, plans for this new location based on the 24 and a half or so feet where they're put here.
All right. Thank you. Any other questions? All right, we're going to go.
No, I don't have any questions. Forget it.
All right, so we are going to open the public hearing for, and this is under old business, VAR 24-151, Brenda Hughes, 120 Doyle Street. Anyone wishing to speak in support of or in opposition to this case, now is your opportunity.
Hi, my name is Carly King. I live at 44 Old House Lane, Morgantown, West Virginia, 26505. I am counsel for the neighbors. We have been in an active lawsuit over this matter for well over a year, going on 2 years. That accessory structure was placed on our property. She knew it was placed on our property when she did it. We had the property staked off in 2017 when we bought it. It was placed later in, I believe, sometime in 2020, I could be a little bit off. But she knew where the property lines were and she still chose to place that shed there. In terms of moving the shed, there is space on the back side of the house for her to move the shed. There's a flat piece of land. I don't know anything about the access road, but there is a very flat piece of land that she could have put the shed to begin with. The shed has caused a huge disruption to my clients and my clients' children. They're students here at the university, all with straight A's and in high degree programs. They have been interrupted in the middle of the night, in the day, by people parking on their driveway, parking in the right-of-way, turning around in their yard, even yelling at our clients on an occasion. And in addition, we believe that someone is living in the shed. We have sent the city out there on multiple occasions. We have produced evidence that the shed has a doorbell camera, the shed has a padlock, the shed has an AC unit in the window, and in this past winter, the shed had a hole cut through it and a hose run through it with a propane tank sitting outside. I'm not sure why the city, I know that the city was out there, I don't know what happened, but we remain confident that somebody is living in that shed. And, not to mention, she put the shed there without getting a permit in the first place. So this was totally improper. She lied to code enforcement about getting a permit in the first place. And so we just would ask that the variance be denied. The shed needs to be removed. It's on our property. It's been on our property for so long. And this has caused nothing but an inconvenience, a headache, a hassle to my clients who have been prevented from just peacefully enjoying their property.
You said it's like a subject of an ongoing lawsuit?
Yes.
Like the shed itself?
Yes, because the shed is on our property, and we have a survey that shows that.
Is it under like a court order?
Do you have the survey?
I do believe I have a copy of the survey. Let me look
See it.
really quickly. I also have a copy of the court order as well. She was court ordered to move the shed by August 17th, which she did not do.
August 17th of what year?
2024.
2024. Yes, yes. Here's a, may I approach? Sorry,
Yes.
we're in court. There's a copy of the order. Let me look for the survey. 1 second.
I mean, this seems like it's under an act, yeah. I mean, this order hasn't been vacated?
No.
Or,
No, we actually are going to have a hearing on that order, to enforce that order, depending on the outcome of this.
I mean, I think we should just
It's-
continue it pending the
Right.
resolution of this case.
So, yeah, because it's an active order, and because we want to avoid,
Interference.
well, logically, if we were to render a decision, it's almost legal double jeopardy, because any decision that we render, it can be, appealed. So, just,
Why? Yeah.
so given the, and.
Well, because even if it was granted, it could be, I mean, from just like a reading of that order, I mean, by granting it, we could be violating the order.
Is it all right if I read the civil action number into the record?
Yeah, it's-
Just so we
it's
can
a-
reference that?
Yes, sir, it's a public record. Go ahead.
So, there is an active order bearing on civil property rights. It's referenced as civil action number 23-C-361, issued by Judge Cindy S. Scott. And just in light of this active order issued by Circuit Court of Monongalia County, West Virginia, we're going to,
Oh, yeah, we gotta leave, still have the public comment and everything.
we do, yeah. I guess, yeah, okay, so, you're right, we'll continue. Do you have anything else to add? Thank you for the exhibits
No, we would just
bearing
request
on this
that,
case.
yeah, we would just request that, you all deny any variance that she requests regarding to the structure and allow the court order to stand so that it can be removed from our property finally. My clients have waited a
I
while.
don't know if we'll use the word deny, we'll move to postpone issuing a decision bearing on any variances by the applicant at this point.
I mean, she was supposed to move this this is last year.
Yes, correct. And that's.
Was there a contempt
Uh,
order following up that followed, or?
So, we are working on that.
Okay.
Yeah, because this has been ongoing. We wanted to provide an opportunity. She was going through the city process. We wanted to provide that opportunity. We were trying to, participate in good faith. There's no good faith left on our part. We're done. We're fed up. And we want this taken care of. And whether you all can do it or the circuit court, up to you all. But we're just trying to get it taken care of.
I think because of our decision, it's subject to appeal by the circuit court. Not that we don't want to help adjudicate,
Absolutely.
but I think we should defer to
The circuit court.
the circuit court.
I agree, but I'm okay with whatever you all do. So, thank you, and feel free to keep those documents. I would honestly like for them to be incorporated into the record if it can be at all.
We'll make sure that Mr.
So,
Thompson-
and if you all need anything else, I believe my name might be on that order, but if not, I've been in contact with Barbara McDonald and Ricky Yeager about this matter, and I'd be happy to speak with anybody further if you need additional information.
So you're Carly King of,
Carly King of Bowles Rice.
okay.
Thanks.
Thank you all
Thank
for
you
your
very
time, I
much.
appreciate it.
Thank you.
Is there anyone else wishing to speak in support? Well, is there anyone else wishing to speak in support of or in opposition to? Okay. I think for rebuttal, should we close the public hearing and then just offer? the
Yeah, what I
opportunity?
would think would make the most sense is that for public meeting involving other than the applicant, you would close that down and then you would
Yeah,
ask
and
the
offer the
applicant.
opportunity to rebut. Yes.
Correct, I think
All right,
that
so,
makes the most sense.
not seeing anyone else wishing to speak in support of or in opposition to this case, at least as regards non-rebuttal, we're going to close the public hearing. Okay. Now, yes, Mrs. Hughes, would you like to?
If you do not grant me the opportunity to move it, how is this thing supposed to be solved? I mean, that's my problem. If I am not granted the opportunity to move it, then this thing will never be solved.
Right, but it's an active case in the circuit court.
I know, but if nobody's going to give me the permission to move it, then it's not going to be solved.
Well, we don't grant permits.
Yeah, we're not granting permission.
But I need the permit or the variance.
Well, the permit is separate legally.
Yeah, I know, but I
separate
need the
from
variance to be approved before I can get the permit to get it moved.
Right.
But we also heard that there was plenty of room down in the backyard.
They're lying about that because I had to put a dog pen in my backyard because they were complaining about my dogs. So that took up the little bit of space that I had in my backyard. Because they complain about everything.
Right. We can't speak to the specific actions you've taken in the wake of, we have it's an active case in the circuit court. And because if we render a decision, we're trying to work toward, our perspective is, trying to work toward the best possible outcome, not only for you, but for all parties. And because, by definition, yes, we adjudicate these cases, but our decisions, because of how the law is structured in the state of West Virginia, our decisions are subject to appeal
Okay,
in the
but-
circuit court. And because that's the case, I can see various scenarios playing out where, even if we were to grant you your variance, if certain scenarios playing out may make our granting you your variance more of a complication than not. Because of that, because it's active in the circuit court right now.
I mean, a circuit court order is going to, supersede
I never
anything
even
we
seen
do.
the documents
Exactly.
that they gave you.
I mean, why aren't you fighting this in the circuit court case? I mean, I think it's,
What we're trying to
My
say
attorney
is-
told you last time we were involved in a court case.
Right. What we're trying to say is to resolve this, the best course for resolution for you and all parties is not through Board of Zoning Appeals. It's through the circuit court. Because it's an active case. It's active.
Maybe I'm not as knowledgeable about it, but to my understanding, this would be more forward-looking in the sense of that is resolved in their way, and then however that resolution goes, then if they have to move it, then they would be able to move it contingent on permits. Maybe I'm just misinformed, I'm obviously not involved with law, but to my assumption of it is being, if this is approved or denied, it affects the permit for this accessory structure.
Right,
And
this is-
not their case. If the
Yeah,
board.
but the case pertains to the structure.
Correct.
Not only the structure, there's many other things involved in the case.
Right, but this specific order.
And those other variables we have no knowledge of, but those other variables, in my view, again, trying to work toward the best possible outcome for all parties, we have no knowledge of what those other variables are. And that's because it's become a complicated case, that's the reason why it's active in the circuit court.
Okay.
That's why. Because, I mean, you mentioned, I wasn't aware of the dog enclosure, that's another variable. And you've got the side yard setback and the topographic variability and the easement. The variable or the options that you have available to you are limited as well.
Yeah.
But, I mean, just given the fact that, again, if we were to grant you the variance, that takes you to the next, okay, now I can proceed to the permit step. But if they just, if it's already active in circuit court, if they decide to further contest, just our granting the variance, that's a further complication for you. That's a further complication for them.
I mean, could you,
When it's already in the circuit court.
Mr. Rollo couldn't be here?
I'm sorry?
Mr. Rollo couldn't be here?
No, he couldn't be here tonight.
I mean, 'cause it would have been nice, because
I
this
know.
order is a little ambiguous. It says apply for an appropriate permit to remove the shed. So
Yeah,
that's
that
not clear to me
doesn't even
whether,
explain really anything.
yeah, I mean, so I
That's
can't,
only
it's a little hard to
an
tell whether
itty-bitty part of
this
it.
is, whether this was actually something that you would be required to do as part of this agreed order,
Yeah,
or if
that's
it's in
not even
violation of the
half
order. I
of
can't
it.
tell from the way this is
No.
written, but I know it's a circuit court order pertaining to this shed.
Yeah, and that's not even half of it.
And it's also this is like a year old, so
Yeah.
it's a little,
Yeah.
a little confused why there isn't more of a resolution to
Exactly.
this one way or the other. So I'm just kind of confused. In one respect, like if we denied it, then you could appeal to the circuit court and then maybe deal with everything there.
Yeah.
And that might actually be,
Because then you could
Be
appeal
better.
our decision.
Yeah.
That might be the best solution, is for us to deny it, and then you appeal to, because again.
because the other fact is if this is denied, the neighbor is going to wants them to it to be removed altogether, right? So this is basically like trying to cut off the ability to move it anywhere, and then they'll be
It just
forced
has
to
to be removed.
Yeah, destroy it. So it's going to end in the circuit court case.
Either way.
Yeah. So I mean, I don't know. It might be better off if we just deny this and expedite things.
That's
It'd be nice. I mean, would have been nice if you.
Or, I mean,
explain what's
we
going on.
can table your case, well, not that that's the best scenario.
I mean, I think what you're saying is like if we continue this, then and you're going to go back to the court, and then they're going to say, come back here and ask for variance again, which that might be the case, but I can't tell.
I know.
We don't have your docket. It's not really our job to figure out what's going on with it.
Exactly.
Well, we're also not supposed to step on the toes of a circuit court judge.
Yeah, we're supposed to.
You want to argue against your own variance? I don't know. I mean,
It's because it's active, it's not.
I think we should just continue it. If you really are supposed to be here and asking for this variance, as you know, if that's what this court order is saying, then you should be able to come back next month.
Okay.
That's not,
But you need, I get some clarity on what's the best way forward for you.
Okay.
'Cause it doesn't do you any good for us to grant you a variance that you can't actually,
Yeah.
even move. If they're gonna get an injunction,
Yeah.
once you start trying to move it. Which is,
Okay.
I'm sure that's what they would do if they started trying to move that shed.
Okay.
All right, should we just up? Or do we need to close this? Or do you have more questions?
anything further to add?
No.
Just get in the, all right, so if you're, yeah, please, have a seat. Should we offer the opportunity, I'm open to allowing the other party to rebut.
I can make it quick.
That's fine. Just in the interest of balance.
Yes, I don't take kindly to being called a liar. I am an officer of the court, and I did not lie. So just wanted to make that really clear. She has been giving these documents, and if she hasn't, that's her attorney's fault. That is not my fault. I am not her counsel. This is an official court order. This was entered by Judge Scott. As I said, the reason for the passage of time is solely because she was going through the city, and we were trying to play nice. We were working through discovery issues as well. Discovery has closed. Go ahead.
Well, can you speak to, in terms of ensuring that it's been executed, who's responsible for that?
It has Judge Scott's signature on it.
But who is responsible for
Oh.
ensuring compliance?
I apologize, I misunderstood your question. It's going to be up to the circuit court, so we're going back on May 15th, and we're going to ask to enforce the order because they have done nothing since this was entered. So that's what we're going to be doing on May 15th, is asking to enforce the order to have the structure removed from our property.
Oh, so you have a hearing date on May 15th?
May 15th at 3 o'clock.
Why don't we continue this to the May meeting? Because there'll be a court ruling on this issue by then,
Yeah, I think that's the best
till May or June.
course. Yeah.
Or just continue it generally until the applicant seeks for a rehearing.
Again, because it's active because it's active in the court.
And there's gonna be a decision something's gonna happen next month with it, so.
Yes, we do have a hearing in front of Judge Scott on the 15th
So-
at 3 o'clock, so we're going to be asking to enforce the order and have the shed removed. Where she moves it to, don't really care, but it needs to leave our property.
Right. Right. So what do you propose? Just a motion to, I'm open to moving that we table this case to, and it's May 15th?
Yes, I believe. That feels right off the top of my head. I said that with a lot of confidence. I think it is.
Okay, well, that would put it just before our May meeting, right?
It would
'Cause
be
it's-
past the deadline for the
Getting
May
it out of
meeting.
that.
It would have to be the June. The earliest meeting from May 15th would be the June 18th. Don't quote me on the exact date, but it would, whatever, that date would be past the one. It would have to be heard in June.
Well, could we just continue it until the applicant seeks rehearing? Generally? Just keep
Like if you wanted to
generally?
table it and then say bring it up next meeting and then.
Because it might be moot. I
Any
mean,
news based on that.
by
Is
the
that?
time we,
Yeah, if you wanted to table it, it would be up to the board, but if the board's decision was to table it until that meeting was given a verdict, and then let's say it is moved like farther out, then just however many Board of Zoning Appeals meetings, you would just have to redo the kind of address it.
oh, so we can only continue it to the next meeting? We would have to continue it
Whatever
at each
one
meeting?
that you
I
guys
think
would
we
be
could,
okay with.
however we wanted to.
It just depends on how you word it.
I say we continue it to the June meeting.
Yeah, so I
That's what I
make
move.
a motion to table this specific case, again, BAR 24-151, Brenda Hughes, 120 Doyle Avenue, to the regular June meeting of the Board of Zoning Appeals, and we're proposing the June meeting to allow time for advertising, meeting advertising requirements.
Do you have a date for the June meeting yet?
I can give it to you after this. I don't.
Is it June or May?
June,
June.
because given the timing of the circuit court rehearing, there's not enough time to allow for the legally required advertising.
Correct.
In terms of announcing,
Neighbor
Meeting
notices, legal notices and stuff. If you guys will wait around after, I can let you know the date, you as well.
Or I'll shoot you an email.
Yeah, that's fine.
Yeah, okay.
Either way
All right.
works.
all right, so are we comfortable with that?
I'll second.
Okay, so we have, so the motion is to table case VAR 21-151, Brenda Hughes, 120 Doyle Street, to the regular Board of Zoning Appeals meeting. And we're making this motion because it's an active case in the Circuit Court of Montague County, and we need a ruling from the relevant judge before proceeding. Thank you, and we have a second, so how do we vote?
Aye.
Aye?
Aye.
So we're tabling your case for now, I'm sorry.
No further questions? No? Okay, all right, thank you. And like I said, I can speak on it, if you all want to talk, happy to talk on it further.
And thank you for the submittals,
Yes, yeah.
the exhibits, okay. All right, we're gonna go ahead and move to the next case, VAR 25-017, Daniels Contracting. Thank you.
Thank you all, thank you.
Thank you.
258 Retail Circle, request by Daniels Contracting on behalf of Mariachi Loco for variance relief from section 1353 of the city's planning and zoning code regarding setbacks and encroachments, City Tax District 9, First Ward, Tax Map 64, Parcel 4, in the B5 Shopping Center District.
The applicant seeks to construct an addition on the left side of their business at the above referenced address. It will be a covered and enclosed space attached to their principal structure. This addition will be used to provide additional service seating for the restaurant use. Similar to the last case, it's kind of a top-down parcel showing of the property in reference where it's located to other parcels and uses, a little bit farther zoomed in to get a better seeing of the site. If you're looking at the one attached in your document, on that kind of leftmost side of it, that's where the addition will go. And here are more kind of zoomed in actual designs of the footprint for that space, being that third attachment as well as up on the kind of presentation, showing where that's going to be located on their property and attached to the structure. Based on the conditions that are listed above, the applicant requested the following. They requested variance relief in the form of 17 feet and 6 inches into their side setback. And that concludes this section of the staff report.
Thank you very much.
Excuse me.
Any questions of Mr. Thompson? All right, do we have, oh, go ahead.
No,
All right. Do we have a representative for this case? Please state your name and address.
Do you need the address for the location?
Yeah, that's.
Okay. My name's Heather Chansey. This is regarding 258 Retail Circle Drive, Morgantown.
And so you're proposing this, can you just speak to the nature of what you're proposing?
So I work for the owner of the building, and I work with Dave Daniels. I've been working on the permit for a while for this location. So we want to build the patio on the side. We'd like to have a covered addition so we can have seating year-round. That space is the only space available that does not affect our parking. And unfortunately, the building was built really close to the property line, so we would need the variance to be able to build the covered addition on that location. There's already a door there on the side of the building that would go, into the patio. We met with Jason Quinn, I believe his name is, with the fire. He said it would not affect any kind of problems with like the fire. So we've met with everybody and everybody's okay with it, other than us needing the variance to be able to actually build the structure there.
Right. And so you are going to enclose it, fully enclose it?
We're going to do 2 phases. We'd like to build just the patio portion and
Right.
the fence.
Right.
And then it would be built so it can be covered in the future. So I've already sent the permit application in for phase 2 as well. So I was working on that.
Okay. So like fully enclosed or just?
Fully enclosed with the roof, sprinklers.
All right.
Yeah, the sliding, he wants to do sliding windows so we can
Right.
open it when it's warm, when it's cold, open it when it's warm and then close it and still have seating year round.
Right.
And the restaurant is very busy. We actually moved from another location into that building, and
Oh.
they really do need additional seating for all of the customers that come in.
Right. Right. Thank you.
Thanks.
Any questions before we open up? Are we ready for the public hearing? Okay. We're going to go ahead and open the public hearing for this case. Case VAR 25-017 Daniels Contracting, 258 Retail Circle. Anyone wishing to speak in support of or in opposition, now's your opportunity to do so. Seeing no one, we're going to close the public hearing. Thank you. We do want to note that additional findings of fact materials were submitted.
Probably should have asked this before. So who owns this? this lot?
Um,
Didn't you say all the neighbors are fine with it, or adjacent property owners?
Can you speak to the adjacent property owners? And how, so the property line is basically, it's the edge of, right?
Do you need me to come back up here?
Yes.
Sure, if
Okay,
you would, thank you. And then if you need to approach to,
Sure, so both of those lots are owned by Walmart. Yes. And with the way that both of those lots are located, whatever they would put there, we would be in the back of whatever building
Oh,
would
because of the
be.
face.
Because the
way
frontage
that
is-
they- Yes.
right? And they'd have to meet their own rear yard setback requirements.
So when you said that they were in agreement with it, or?
Everyone we met with the city
Oh,
said
yes.
that, yes, no, I was not referring to the Walmart. I would assume that when that was advertised in the newspaper, that they would have had the opportunity to,
Yeah, the legal notice was put into the paper, as well as a mailing notice was sent out, which Walmart was one of the people that would have been
Oh,
on
yeah,
that,
they
as
take
well
care of
as
themselves.
signage was
Yeah,
located.
I'm asking, I'm like,
And in terms of the correspondence, the notice is sent out, what's the radius?
200 feet.
It's 200 feet.
Oh, it didn't show on this one. Yeah, it basically, since the parcel touches like kind of Walmart's, they were
Right.
gone. That's technically 1 foot away from it started at their boundaries, not their structure. So
Right.
within 200 feet of parcel, the
Yeah, it's the
250
property
retail.
owners, not the affected,
Correct. And it-
impacted structures.
Yep. So everybody within 200 feet who owned a parcel or, would be on that, would have received a mail notice.
Right.
and what is the, from that property line, what's the typical
it's,
setback for it?
30, so from their side, it is 30 feet and in the B5, which, yeah, in the B5 district, the side setback is 30 feet exactly, and their structure is
So they're
roughly
more
on
than into
the
the-
30 feet.
They're more than half into the 30-foot side yard, so.
They would
At
be
17,
doing-
because what is it, 17?
it's,
Six.
it was about 7.
Yeah, 17 feet and 6 inches. I believe that number was from, I talked with the contractor, and that is kind of his closest measurement without having,
And we had looked at options of possibly making it longer, but that makes the patio, it's way too narrow.
Right.
There was no other way. And then if we would put it on any of the other sides, we're still, on the other side of the building, we would still need a variance, plus we lose
It's
parking
impacting
spaces.
Parking.
Yes.
Not that you're coming to us for a parking variance, that's not really the
correct.
primary challenge here.
This wouldn't put them under the parking requirement.
I guess, I mean, what,
I don't have a problem with anything, it's just, it's the same issue that it is with all these variances, which is like we have to squint when we talk about special conditions, attributes of the property. Because
and what, I mean, what's the, I mean, you indicated that you've already had, because, and you're running a very successful venture. Good for you. I guess I pose the question, what's the hardship? But then again, you've already relocated once,
but you guys just.
and you have, the nature of your venture is to succeed.
And we
And-
actually purchased this building. We own it. It's not a rental. We own the building.
Right.
Yeah.
I guess the hardship is, if we don't grant, is it, but on the other side of that, can you really demonstrate what your hardship is? On the other side of that is, it's not an unreasonable development of the property.
To also reference this, as she said, it's a 2-part kind of development plan, and part 1 is this outdoor patio seating.
Is the footprint.
Which is the same footprint, and that's actually, they do not need a variance for that. That's just going through normal reviews right now. With that patio portion,
Oh, it's the
either-
enclosure technically that's...
Yes, which is
Ah.
causing, if they were just looking for outdoor patio seating with a railing, they would not be here. This is for forward-looking and closing it into an addition.
It's the enclosure.
But the footprint won't change. It'll just go from being an open patio to being enclosed. The patio, I believe, can be within like 5 or 10 feet of the property line, which they would have at minimum, the 30
They're still
foot
13 foot away from...
Correct, so, not off the top of my head of
Set lot
what the
anyways.
requirement is, it would be.
Right.
yeah.
Unless they sell it.
And it would be, yeah.
I mean, that's just the exit out there.
Yeah, so the patio will still go in with or without the enclosure. It's just we'll have the ability to cover it later on to have seating year-round. And on the other building that we moved from, it actually was the center right beside us. You can actually see it on the first image. We had a patio there, so we actually moved to a smaller location with the plans of actually building this covered patio, and it's our fault, and I understand that, but we weren't aware that we couldn't build that close to the property line. We weren't aware that there was 30 feet, and they have been really busy there.
Right. Now, correct me if I'm wrong, the variance is specific to the owner, operator, right?
The variance, to my understanding of it, is attached to the property.
Oh, it's, okay,
parcel.
runs with the property, okay.
So if, let's say, next week, they sell it and they're like, hey, we're done doing this, and another owner acquires this property, they would have the 17 foot 6 inches into the side setback for whatever.
The new owner
Correct.
would not have to apply
No.
for the continuance of the variance.
Unless it extends it more than what's being asked for.
Right,
which
but that's
is-
a new variance.
Of course, yep,
Okay.
yep, you're 100% right.
So that's kind of out of our purview, but if you were to, something were to change and you opted to sell, that wouldn't be an encumbrance. From the perspective of the new owner operator.
Sure, they would still have
So-
that variance.
Correct.
That's kind of out of our purview, but just something to take into consideration. Okay. I mean, it's pretty straightforward. Any other questions? No? All right, thank you. So, any other discussion? Do we have, is everyone, I mean, we had, in addition to findings of fact, number 2, number 4, I mean, they're fairly straightforward findings of fact. I just want to say, you know, it's a reasonable, the variance is reasonable, it represents a reasonable development of the property.
I mean, yeah, I mean, it seems odd to worry about a setback when, like, the other side of the porch is just their parking lot.
Right.
I mean, there's absolutely no activity on that adjacent property
Right.
at all to even be
And it's-
interfering with.
And they're not
And
here.
it's-
They're not here.
And, I
It
mean,
seems like an
it's
excessive setback for, honestly,
in a commercial,
and
commercially zoned, yeah, area. And it's not as if there are adjacent residential districts, it's commercial. So I am going to make a motion to accept the findings of fact for case VAR 25-017, excuse me, Daniels Contracting at 258 Retail Circle.
I second.
Okay, so we have a motion to accept the findings of fact, taking into consideration the additions that were made at the opening of this meeting. And we have a second by Ms. Cook. How do we vote?
Aye.
Aye. So we've accepted the findings of fact for VAR 25-017, Daniels Contracting, 258 Retail Circle. Do we have a motion to grant the variance?
Yes.
And we also,
Was there any,
are there any conditions,
city.
Mr. Thompson, can you speak to that?
Yes.
Any unusual conditions, the usual conditions applied?
Correct. So staff have no objections to the applicant's request for variance relief. If the Board of Zoning Appeals grants the applicant variance from Section 1353-04A2 of the city's planning and zoning code, the new addition shall be subject to the following condition, being that if anything else was to change that would require a variance, then they would come and seek a variance or adjust their plans accordingly.
And that single conventional condition is referenced on page 24 of the meeting packet.
Yep. Okay, I move that we grant the variance with the condition mentioned in the packet as for moving forward.
And I second that motion. All those in favor, say
Aye.
aye. Aye. So we have granted your variance request for your case. Please keep in mind, or you will receive written notification 7 to 10 business days from planning. And of course, keep in mind, regardless of whether we approve or deny, decisions of the board are subject to appeal in the Circuit Court of Montague County within 30 days upon receipt of the written notification. So just keep in mind, any work that you or your client undertakes during that 30-day window, you do at your sole financial risk. Thank you very much for coming down this evening. Have a good evening. Do we have any announcements?
No announcements other than there will be a BZA next month. We have a couple variances for
Thank
it.
you.
Otherwise, no outstanding announcements.
I move we adjourn.
We have a motion to adjourn. I second that, and we are so adjourned.